Background to Proposition 8. In November 2000, the voters of California adopted Proposition 22 through the state's initiative process. Entitled the California Defense of Marriage Act, Proposition 22 amended the state's family code by adding the following language. Only marriage between a man and a woman is valid or recognized in California. California Family Code, Section 308.5. This amendment further codified the existing definition of marriage as a relationship between a man and a woman in remarriage cases. In February 2004, the mayor of San Francisco instructed county officials to issue marriage licenses to same-sex couples. The following month, the California Supreme Court ordered San Francisco to stop issuing such licenses and later nullified the marriage licenses that same-sex couples had received. See Lockyer versus City and County of San Francisco. The court expressly avoided addressing whether Proposition 22 violated the California Constitution. Shortly thereafter, San Francisco and various other parties filed state court actions challenging or defending California's exclusion of same-sex couples from marriage under the state constitution. These actions were consolidated in San Francisco Superior Court. The presiding judge determined that, as a matter of law, California's bar against marriage by same-sex couples violated the equal protection guarantee of Article 1, Section 7 of the California Constitution. In Coordination Proceedings Special Title Rule 1550C. The Court of Appeal reversed, and the California Supreme Court granted review. In May 2008, the California Supreme Court invalidated Proposition 22 and held that all California counties were required to issue marriage licenses to same-sex couples. From June 17, 2008 until the passage of Proposition 8 in November of that year, San Francisco and other California counties issued approximately 18,000 marriage licenses to same-sex couples. After the November 2008 election, opponents of Proposition 8 challenged the initiative through an original writ of mandate in the California Supreme Court as violating the rules for amending the California Constitution and on other grounds. The California Supreme Court upheld Proposition 8 against those challenges. Strauss v. Horton. Strauss leaves undisturbed the 18,000 marriages of same-sex couples performed in the 4.5 months between the decision in remarriage cases and the passage of Proposition 8. Since Proposition 8 passed, no same-sex couple has been permitted to marry in California. The Due Process Clause provides that no state shall deprive any person of life, liberty, or property without due process of law. The Equal Protection Clause of the 14th Amendment provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. The guarantee of equal protection coexists, of course, with the reality that most legislation must classify for some purpose or another. When a law creates a classification, but neither targets a suspect class nor burdens a fundamental right, the court presumes the law is valid and will uphold it as long as it is rationally related to some legitimate government interest. In conclusion, the California Supreme Court found that Proposition 8 fails to advance any rational basis in singling out gay men and lesbians for denial of a marriage license. Indeed, the evidence shows Proposition 8 does nothing more than enshrine in the California Constitution the notion that opposite-sex couples are superior to same-sex couples, because California has no interest in discriminating against gay men and lesbians, and because Proposition 8 prevents California from fulfilling its constitutional obligation to provide marriage on an equal basis, the court concludes that Proposition 8 is unconstitutional.
Because if you're gay or whatever, if you're gay, lesbian, transsexual, whatever, it sucks because they can't be completely happy because they can't be married. So I mean, yeah, we're all human beings. Who's to say that, I'm not allowed to get married, or who's to say, no, you're not allowed to get married? Who has that right? I mean, you guys are marrying each other for, for the sake of YouTube. And that's all that really boils down to. It's just sad that they can't get the same rights as everybody else. I mean, we're all human beings. I don't see why they shouldn't get those rights.
I think it should be legalized because, you can't judge people on how what they cannot control.
I believe that people are people, and that if there are two people, no matter what their sex are, they should be allowed to be married.
Being an old union man, if you got a good job and you're making money, and there's benefits, and you have a significant other, you should be able to share the benefits with the other.
Kennedy, I really think that he is more liberal, so I'm hoping that it will go in favor of.
I think they'll let the states decide.
You know, love is love. We all got the same love here, so.
It's a beautiful night. We're looking for something dumb to do. Hey, baby.